And then the other example was,
Copying the checker out of an examination copy.
right, once again, you look at those factors.
So the fourth one would trump it.
It could, yes, it very well could. The fourth factor could very much trump it. I mean, I'm concerned about this right now because I have Brian Poulter and I, a colleague, have published a CD, and in fact, it's interesting. Now, Wadsworth Publishing paid us as a work for hire, so they paid us a set amount of money to be able to put this CD in this textbook, so that it's in this textbook. So we've already been paid for our work for this book, in this book. Okay.
So you don't own the copyright.
No, they own the copyright. In fact, so we signed a contract. So this was a work for hire agreement. We got X amount of dollars. I'm going to tell you how much money we got.
You could get an iPod out of it.
We got X amount of dollars as a work for hire for this book. Now, in addition, they have published a standalone version. $42 is what this sucker costs. And so we get 10% for all single copies sold. And plus, they say they're probably going to put it in some other books like this. We will get 10% for, I'm assuming whatever, because they actually put this in this book for free. I'm assuming they would jack the price up of any other books they put it in, and we will get 10% of the additional cost that they add to the other books they put it in. So of course, first thing I'm bringing, obviously, I mean, somebody gets this, they could put it on their. I mean, it'd be really easy to rip this off. Very, very simple to rip it off. And so, of course, I'm very concerned about that because every time that's ripped off, I lose money. Brian and I each lose $2.30 or whatever for every time this gets ripped off and somebody uses it without paying for it. So, and this is a good example of how there are a lot more educational things out there that people really should be paying for. I'm a big supporter of that now. But yeah, obviously we sold. Obviously we signed over the copyright to them. So Wadsworth Publishing Company owns the copyright on that, and we have first rights to update it. The contracts, when they want to update it. And we have a non-compete clause. We can't create other things that would compete with this. That's part of the agreement too. But I know good and well somebody's going to say this was a great, and I think it was a great idea if I say so myself, because they obviously thought so, and two or three other publishers who wanted to publish it. So I know good and well 2 or 3 other people are going to rip this off. And take the idea and do another version of it. There's no doubt.
They can steal your idea.
But they can. Yeah, they can. As long as they create new things, they can certainly do it. And I know good and well, within a year, that's going to happen. There's no question about it. So the fair use obviously is very, very critical, and you just have to look at all 4 factors and weigh those, and sometimes they'll work. But let me just give you a couple of quick examples there. Okay, here's a good example. This is a federal case, 1986. In 1973, the plaintiff wrote a book based on interviews with women about their own pregnancies and abortions. The defendant wrote his own book on the same subject and sought permission to use lengthy excerpts from the plaintiff's work, from the original work. The plaintiff refused permission, and the defendant proceeded to publish his work with the unpermitted excerpt. So he said, hell with it, I'm going to do it anyway. So he did it anyway. So, of course, the original plaintiff, the one who wrote, sued. The second person, the defendant, claimed fair use. The court said, okay, the purpose, although defendant's book was published by a commercial press with the possibility of monetary success, the main purpose of the book was to educate the public about abortion and about the author's views. Now, one thing that's interesting in this was that the original author was opposed to abortion. The second author was favored abortion. So that was part of the sort of the underside here. You know, the person didn't want a pro-choice book using some things from the anti-abortion thing. So the court basically said, oh, the purpose, even though it was commercial, it was to inform. Therefore, they ruled that at least the purpose part of it was in favor of fair use. The nature, the interviews were largely factual, so that would weigh in favor of fair use. The amount, quoting 4.3% of the plaintiff's work, was not excessive, and the verbatim passages were not necessarily central to the plaintiff's work. And the effect, the court noted that the plaintiff's work was out of print and not likely to appeal to the same readers. The two books appeal to opposing views of the abortion controversy. So the court ruled that it was fair use. So that's sort of an example of how that might work. Or in the case of one of the other course pack cases, basic books incorporated with Kinko's in 1991. Kinko's was held to be infringing copyright when it photocopied book chapters for sale to students as course packs for the university classes. So Kinko's claimed that this was fair use. Okay, purpose. When conducted by Kinko's, the copying was for commercial purposes and not for educational purposes. The court left open the possibility that the purpose may weigh in favor of fair use if the copying was done within the college or university. Because Kinko's did it, that weighed against fair use. The nature. Most of the work was factual, history, sociology, and other fields of study, a factor which weighed in favor of fair use. Amount. The court analyzed the percentage of each work, finding that 5 to 25% of each of the original full books was excessive. And the effect, the court found a direct effect on the market for the books. The course packs competed directly with the potential sales of the original books as assigned reading for the students. So that's sort of is close to your examples. I mean, so you sort of get into trouble there. So 3 of the 4 factors leaned against fair use. The court specifically refused to rule that all course packs are infringements, requiring instead that each item in the anthology be individually subject to fair use scrutiny. So you'd have to analyze each individual thing before you could decide that. So anyway, that gives you some examples there of how you would do that. Now, I might mention also in this same regard, when we're talking about when you taking something from in print and putting it in a CD or putting it in a database. U.S. Supreme Court several years ago, a case called Ticini versus New York Times. The New York Times and other publishers had been, contracting with freelance writers. Freelance writers would do stories, whatever, and then the New York Times and other things would then put these into databases, the LexisNexis or these other databases. So these freelance writers come back and say that violates our copyright. You have taken this and put it in other forms, and therefore that violates copyright law. Now, in the time when this became a debate, after this became an issue, all these publications changed their boilerplate to actually make sure that all of these things were covered. But the original plaintiffs, all they had done was say, they've given them rights to sell this in the New York Times. Now, the statute, the whole case was based upon an obscure part of the copyright law, which only lawyers, would care about. But I think it's important to understand what they meant here. The key here was a collective work.